Good morning, Namaskar. A hearty welcome to third session of webinar series on interstate river water disputes in India. In our previous session, we seen the topic of existing central laws and enactment relating to interstate river water disputes in India and role of Central Water Commission, which delivered by Honorable Speaker Shri B.P. Pandey sir, Chief Engineer, Central Water Commission. During his last session, he briefly enlightened us the topics on River Board Act 1956, Interstate River Water Dispute Act 1956, then amendment to the Interstate River Water Dispute Act on 1956, then enactment of other central laws, Andhra State Act 1953, Punjab Reorganization Act 1966, Uttar Pradesh Reorganization Act 2000, then Madhya Pradesh Reorganization Act 2000, Bihar Reorganization Act 2000, Andhra Pradesh Reorganization Act 2014, and role of Central Water Commission in resolving the interstate water disputes in India. Today, a warm and cordial welcome to extended to our esteemed speaker of today's session, Shri B.P. Pandey sir. Shri B.P. Pandey sir is graduated in civil engineering from MA-NIT Bhopal in 1987. He did his MTech in water resources from IIT Mumbai, and then he joined Central Water Commission through UPSC Engineering Service exam in 1990. He worked in various departments of Ministry of Water Resources from 1992 to 1995. He dealt with water dispute resolution and interlinking of river matters. He worked as Deputy Director in Kaveri Water Dispute Tribunal, New Delhi from 1995 to 1998, and was involved in examination of claim and counter claims of basin states on water availability, then irrigation water requirement, validity of past agreement on Kaveri. He further worked in Ministry of Water Resources from 1999 to 2007 as a Deputy Commissioner and dealt with the water dispute resolution of Krishna, Mahadayi and Vamsdhara River matter water disputes, amendment of Interstate Water River Dispute Act 1956, settling up of Krishna Water Dispute Tribunal 2 means KWDT 2 matter related to Kaveri River Water Management Authority, Monitoring Committee on Kaveri and Interlinking of Rivers. He was also associated with hydrological observation and flood forecasting in Northeast region from February 2008 to May 2010, work as a superintending engineer, and then from June 2010 to March 2019, he was Director Interstate Matters in Central Water Commission. During his tenure, he dealt with preparation of further references on reports of KWDT2, Vamsdhara Water Dispute Tribunal, Mahadayi Water Dispute Tribunal, and also represented ministry in these matters before the tribunal. He dealt with matters related to Supervisory Committee of Kaveri constituted for monitoring the implementation of final order of CWDT. He also dealt with SLPs filed by Karnataka and Tamil Nadu on final order of CWDT and attended hearings in Supreme Court from 2016 to 2018. Also dealt with appraisal of irrigation and multi-purpose projects from interstate angle during his tenure as a Director Interstate Matters in Central Water Commission. Today's session, he will briefly touch upon the various important topics of the today's webinar on overview of existing and proposed water regulation in India. Today he will briefly light on the Water Prevention and Control Pollution Act 1974, Environment Protection Act 1986, Policy Statement for Abatement of Pollution 1992, then National Conservation Strategy and Policy Statement on Environment and Development in 1992, National Environment Policy 2006, the Forest Conservation Act 1980, then Groundwater Regulation, the Indian Easement Act 1882, Central Groundwater Authority CGWA, then Model Bill for Groundwater 2016, Dam Safety Act 2021, Draft National Water Framework Bill 2016, which is very important bill. Again, one more important bill on Draft River Basin Management Bill 2018. Let us start today's session, and remember that these webinars are not just platform for dialogue but also opportunities for growth, learning and collaboration. The knowledge gained here has the potential to influence policies, decisions and actions that impact our nation's water resources and its people. Thank you, and let us begin the third session of our webinar session on interstate river water disputes in India. Now I request our today's speaker, Shri Pandey sir, he will start his session. Please, Pandey sir.
Okay, thank you, Mr. Patil. And I wish good morning to everyone who is online in this webinar series. As a brief introduction of the topic has already been given by Mr. Patil. So I will be straightforward, begin with the content of the presentation. So this is the first topic of the presentation, that is water within bracket Prevention and Control of Pollution Act 1974. So this is one finest example. Passing of this act by Parliament is one of the finest example of cooperation in the water sector, because there is no explicit power available to Parliament to legislate on the subject matter of water. Water as a subject is in the domain of the state governments. But then there is a provision in the Constitution under Article 252 that Parliament can legislate on the matters which pertain to the state government if the resolution is passed by the state assemblies to that effect, and it is communicated to the central government. So in run-up to the passing of this act, about 12 state assemblies passed resolution for enactment of such kind of act, and thereafter the Union Parliament passed this act in 1974. So in a way, such kind of cooperation is rarely available. Hardly one or two state assemblies coordinate in such matters. So this particular act basically focuses on the quality of water, maintaining the quality of water. So, and as we will see in our presentation, that it also provides for institutions to carry out the purposes of the act. So what basically it provides that there should be boards at the central level, board at the central level, and the boards at the state level, and because the initially only 12 states passed resolutions for passing of this act. Therefore, initially this act was applicable only in those states where assemblies have passed resolutions. And later on, if other state also wants, this act can be made applicable. So initially it was applicable for 12 states, and I think now it is applicable in almost all the states and union territories. So there will be a board at the central level, and then there will be board at the state level. And at present, there are 64 sections in this act. So there are some basic definitions in this act, like pollution, sewage outlet, sewage influent, trade influent, and streams. And interesting thing is that streams cover a wide range of things like normal streams, then subterranean water, then even the coastal areas, which can be notified by the state government as streams. So the main function of the Central Pollution Control Board is to promote cleanliness of streams and wells in different areas. That is the main function. And then, without generality to this function, there are some specific functions like advising the central government on any matter concerning the prevention and control of water pollution, coordinate activities of the state boards and resolve disputes among them, provide technical assistance and guidance to the state boards, lay down, modify, or annul, in consultation with the state government concerned, the standards for streams or wells. So there are some other functions also listed in the Act. So these are some of the important functions. Now moving on to the state pollution control boards, they have some additional functions. So apart from this kind of functions, and there are functions like inspection of sewage or trade effluents, works and plans for treatment of sewage and trade effluents, and to review plans, specification, or other data relating to plants set up for the treatment of water, works for the purification thereof, and the system for the disposal of sewage or trade effluents, or in connection with the grant of any consent as required by the Act. So it now, because consent word is here, so if new industry is to be set up or new locality, something like that, new local authority, then if permission from the state boards is also required if they are going to use the water. So what kind of quality of water they will be discharging into the streams and all such things. So that kind of activity is also covered under the jurisdiction of the state boards. Then it has provision for establishment of central water laboratory and state water laboratory also, because if the board has to monitor the quality of the water, then it should have some standard laboratory. So that is why this kind of provision was made there. And in the laboratory, then there should be proper qualified officers. So there is provision for appointment of government analyst for the purpose of analysis of samples of water or of sewage. And the Act was amended in 1978 and 1988. The last amendment was to conform closely to the provisions of the Environment Protection Act 1986. Now, apart from boards, there is a provision for pollution control committees also to regulate the discharge of effluents and enforcement of standards. Then what should be the funding pattern for the boards? So there is a provision in the Act that the board should have its own fund. And normally most of the funding will be done by the central government. And if other revenue is received by the board, that will also constitute the fund of the board. Similar provision is there for the state boards also, that they will be funded by the state government, but other revenue received by the board shall also be part of the board's fund. But then there was some thinking after 1974 that apart from the funding from central government, there should be some additional resource for funding of the boards. So then a Water Prevention and Control of Pollution Cess Act was enacted in 1977 to provide for levy and collection of cess on water consumed by persons operating and carrying on certain types of industrial activities. Now here persons means local authorities are in charge of industry, not individual persons. It is defined in the Act itself. So then cess is collected by the board, and then part of it goes to the board, and then part of that goes to the central government also. The last amendment with the Act was in 2003. So there is procedure prescribed in the Act for how to calculate the quantity, how to assess the cess on the quantity of water consumed by the persons, and then the cess is levied at such rate as specified in the schedule of the Act. Now this schedule is something which can be amended from time to time by the government without going to the parliament. So that is why these provision for rates is there in the schedule, not in the Act itself. So that depending on the situation and funding position or financial position of the boards, schedules can be modified. So this in nutshell is about the Water Prevention and Control of Pollution Act 1974. Then we come to the Environment Protection Act 1986. So this act was passed under Article 48A of the Constitution, which is under the directive principles of the state policy. And it is an umbrella legislation designed to provide a framework for the coordination of central and state authorities established under Water Act 1974. And then I am not touching this Air Pollution Control Act because that is not related to water, but it is also there. So this, and apart from that, there are some other functions also in this act. So essentially, the first thing has to be that what is environment. So this act tries to define that, and as per the definition in the act, environment includes, means it is not limited to these things. Environment includes water, air, and land, and interrelationship which exists among and between water, air, and land, and human beings, other living creatures, plants, microorganisms, and property. So in a way, it is quite comprehensive, and it covers almost anything and everything. Then it has also, because in Water Act only water pollution thing was defined. So here environmental pollution, pollutant is also defined as any solid, liquid, or gaseous substance present in such concentration as may be or tend to be injurious to the environment. So that is what environmental pollutant is understood from this act. So under this act, central government is empowered to take necessary measures to protect and improve the quality of environment by setting standards for emissions and discharge, regulating location of industries, management of hazardous wastage, and protection of public health and welfare. Now, this regulating location of industry, I have mentioned in short here, I will come to this in detail later. That is very important, and this particular provision has been made use of for even for water resources project also. Then this act, as usual, in every act there is a provision for framing of the rules. So in this act also, so there are two sections particularly for framing of the rules, and accordingly, central government framed rules immediately after the act, passing of the act in the year 1986 to carry out the purposes of the act under different sections. So this was the initial action taken by the central government for implementation of the provisions of this particular act. Then policy statement for abatement of pollution in 1992. So while this Environment Protection Act was in place, this policy statement was also promulgated in the year 1992. And the objective of this document is to integrate environmental consideration into decision making at all levels. So, and then to achieve this, the document lays down steps to be taken to prevent pollution at source, encourage, develop, and apply the best available practicable technical solutions. And the important thing is that as the title itself suggests, that it lays emphasis on pollution prevention in place of conventional end of the pipe treatment, because this Water Pollution Act and even Environmental Protection Act basically aimed at the treatment process, but the policy is prevention. Its treatment may not be required. If we prevent something, then treatment at all may not be. So it is from that point of view. So it is also it also identified the adoption of best available and practicable technologies as the key element for pollution prevention. So this is in a very, because but my topic of presentation is overview. So I am giving the topics introduction in a very short manner. Details can be seen in the website of the Ministry of Environment and Forest. Then another policy was promulgated by the central government in the 1992 itself. Sorry, this is continuing of the same. So the focus of various programs and schemes of the ministry and its organizations related to pollution prevention and control is therefore on such as promotion of clean and low waste technologies, waste minimization, reuse and recycling, improvement of water quality, environmental audit, natural resource accounting, development of mass-based standard, institutional and human resource development. The whole issue of pollution prevention and control is dealt with by a combination of command and control methods, as well as voluntary regulations, fiscal measures, promotion of awareness. So this is about this pollution abatement policy. Then there is another policy adopted by union government, that is about National Conservation Strategy and Policy Statement on Environment and Development, 1992. So this is something to add the objectives as set forth in the Environmental Protection Act, 1986. So the national policy in response need for laying down the guidelines that will help to weave environmental consideration into the fabric of our national life and our development process. That is very detailed statement given in 2 words. Then it is an expression of India's commitment for reorienting policies and actions in unison with the environmental perspective. Then it talks about the nature and dimensions of the environmental problems, action taken in response to the problems, and list out priorities and strategies for action. It also views development policies from environmental perspective and the support policies and systems required. So this is in very brief the introduction to this particular policy, and details can be seen on the website of the Ministry of Environment and Forest. Then coming to the expanding of the activity done under Environmental Protection Act 1986. So there is this very important sub clause in the act, which is 325. That means clause 5 of subsection 2 of section 3, that the central government has the powers to take measures in respect of restriction of areas in which any industries, operation or processes or class of industries or operations or processes shall not be carried out or shall be carried out subject to certain safeguards. So this is very important provision. And then central government and the Ministry of Environment and Forest has made use of this particular clause to cover so many projects and schemes, and to screen the establishment of industries, operation and process or project before they are actually taken up. Then under Rule 53A of EPR 1986, so central government may give notice of its intention to impose prohibition or restriction on the location of industry or the carrying on of processes and operation in an area by notification in the official gazette, if it appears to it that it is expedient to do so. So now how to give effect to the provisions of this section 325? So that is the procedure laid down, that finally in the first instance it has to publish its intention in the official gazette and invite objections for that. Now there is a time limit for that processing, receiving the objections. So this section, Rule 53D of EPR 1986 comes in place, and it lays a period of 120 days from the date of publication of the notification official gazette to consider all objections received against such notification, and may within 180 days impose prohibition or restrictions on location of such industries and the carrying on of any process or operation in an area. So now this is the procedure prescribed, that using the powers under section 325, then 53A and 53D, central government can achieve the objective of section 535 of the Act. 325 of the Act. So using that those provisions, then the Union Ministry of Environment and Forest read with these rules, notified an environment impactment assessment notification making environmental clearance mandatory for undertaking any new project or the expansion or modernization of any existing industry. And it in the schedule it listed a certain number of areas where such kind of things is required. So this notification provided for impact assessment agency and committee of experts. Now coming to river valley projects, though these projects are find mention under entry 2 of the aforesaid schedule. So any agency or authority, if it intends to undertake any river valley projects, either for hydropower or major irrigation or combination of both, so they have to first obtain the site clearance from Ministry of Environment and Forest. So it was made compulsory from 1994. Now a time limit has been set forth, that assessment, when an application is received, then it has to be completed within 90 days from receipt of all documents and decisions, to be conveyed thereafter within 30 days. And the clearance was to be valid for 5 years for the commencement of construction. But no site clearance was required if investment was less than rupees 50 crore. So these were the basic provisions. The notification is very detailed one, and it can be accessed on the website of the Ministry of Environment and Forest. Then this building on the earlier policy, the Ministry of Environment and Forest adopted another policy, National Environment Policy 2006. And this was in response to India's national commitment to a clean environment mandated in Constitution under Article 48A and 51G and strengthened by judicial interpretation of Article 21. So it is intended to be a guide to action and regulatory reform, programs and projects for environmental conservation, review and enactment of legislation by central, state and local government. The dominant theme of this policy is that while conservation of environment resources is necessary to secure livelihoods and well-being of all, the most secure basis for conservation is to ensure that people dependent on particular resource obtain better livelihood from the fact of conservation than from degradation of resources. The policy also seeks to stimulate partnership of different stakeholders, public agencies, local communities, academic, scientific institutions, the investment community, international development partners in harnessing their respective resources and strengths for environmental management. So overall objective is preservation of environment, preservation and conservation of environment. Now, building on this objective of this policy, the central government issued another notification in 2006, which superseded the notification of 1994. And then it decentralized the process of environmental clearance by issuing this notification by categorizing the developmental projects into two categories. Category A, national level appraisal. So these require mandatory environmental clearance from MOEF and CC on the recommendation of expert appraisal committee. Then category B, state level appraisal. These require mandatory environment clearance from State Environment Impactment Assessment Authority constituted under Section 3(3) of the Act on the recommendation of State Expert Appraisal Commission. So this created rather decentralized the process of environmental clearance at the central and at the regional level and the rather state level, and it also categorized the projects into A and B category, and even under B there are two B1 and B2 categories. So category B projects are classified into two types. Category B1 projects mandatorily require EIA. And how this is decided? This is decided after the screening. Once the proposal is submitted, and there are some category, some projects are mentioned as category projects in the annexure to the notification. A and B category are mentioned, but B1 and B2 has to be decided by the screening committee once the proposal is submitted by the user agency or some authority. And then category B2 project do not require EIA. So then river quarry projects with hydroelectric power generation capacity greater than 50 megawatt and CCA greater than 10,000 hectares were categorized as category A projects, and less than these were categorized as B project. And in B, then this screening committee further divides them into B1 and B2. The project authorities submit an application in the for category A projects, and then ESCs are required to screen, scope, public consultation, and appraise project in their respective domain. So, in case of category B projects, it has to be submitted to the state level thing, and category A project to MOEF. And then state level this thing authority has to screen this thing and then decide whether it has to be given EIA or without that it has to be done. But at central level, this category A project is there, and then there are 4 stages appraisal process for category A projects. So first stage is scoping, and that is done for framing detailed TOR for doing EIA to be conveyed to the project authority within 60 days Then there is a public consultation process also. So it involves public hearing and written response also. Both things are required to be done. Then appraisal means all those things, this public hearing, report, written response, and then according to TOR, to the information collected. So all these things are scrutinized by the expert appraisal committee, and then suitable recommendation is given to the Ministry of Environment and Forest. And then MOEF issues the environment clearance, which is valid for 10 years in case of river valley projects. Now, these rules have been amended several times, and I am mentioning here the rules which relate to river valley projects. So, the amendment of year 2009 mentioned that irrigation project not involving submergence or interstate domain shall be appraised by the State Environment Impact Assessment Authority. Now, here interstate domain is something different than what we understand in CWC. Here is something like that. It is, if it is located something below 10 kilometers from the border, interstate border, then involve interstate. There is submergence, then that is also involving interstate. So this provision was made in 2009. Then in 2014, non-irrigation projects such as large drinking water supply projects having a submergence area greater than 5,000 hectares were categorized as category A projects, and they will naturally be required to get environmental clearance. Then in January 2016, dredging and desilting of dams, reservoirs, weirs, barrages, rivers, canals for the purpose of their maintenance, upkeep and disaster management were exempted from prior environmental clearance. So this indicates progressive thinkings on part of the parties. Then in 2018, again this category of irrigation project was enhanced. Now irrigation project greater than 50,000 hectares of CCA were categorized as category A projects. And within CCA 2000 categorized category B. And even under this medium irrigation system, between 2,000 to 10,000 hectares required to prepare EMP and to be built at state level, B2 category. So it also mentioned that category B river valley projects falling in more than one state shall be, in any case, that shall be appraised at the central government level, even if they are medium. So then change in irrigation technique. This is for existing project. So if some ERM scheme comes or modernization is envisaged, then in that case also, if there is no increase in the height of the dam, then some environment clearance is not required. So this is the journey traveled by the provisions of environmental clearance in respect of irrigation projects till the date. There is another provision from this line of control and obtaining environmental clearance. So one of them is 100 kilometers from line of control. Then last amendment has been carried out in 2002 to 23, and this is not about irrigation but hydroelectric projects. So this is for pumped storage projects. So some provisions have been made, and the pumped storage project have been exempted. Pumped storage project of certain category have been exempted from prior environmental clearance. So this is the journey of environmental protection rules so far as it relates to the river valley projects. And this because Environment Protection Act and environment itself is a very vast area. So there are many things which are being covered by this Environmental Protection Act, and Ministry of Environment and Forest is the ministry concerned with dealing with the environmental clearance and they have now made it online system for almost everything, including forest clearance, environment clearance, wildlife clearance, and so many other things. So detailed procedure and some issues requiring clarification can be seen in the website of the Ministry of Environment and Forest. क्या हो गया भाई? अभी कुछ हो जाता है, कभी कुछ हो जाता है. Decline करो please. अभी नहीं चलो. हाँ. अभी गया. Now, this Forest Conservation Act, this is very important legislation to prevent large-scale deforestation, and it was enacted in 1980. So, this is a very short act, but it has a very huge impact, and it has a very important role in conservation of the forest. So, it was enacted to provide conservation of forest for matters connected therewith or ancillary or incidental thereto. So, but basically there are three functions, four activities which are regulated by this act. But one of them is that prior approval of central government is required for derivation of any forest land for non-forest purposes. So, because our irrigation projects are often located in forest areas, so this is very important for taking up the irrigation projects and hydroelectric projects, river hydroelectric projects. So I am therefore briefly touching this also here. So this is exact provision in the Act, notwithstanding anything contained in any other law for the time being, in force in a state. No state government or other authority shall make, except with prior approval of central government, any order directing that any forest land or any portion thereof may be used for any non-forest purpose. Now, this non-forest purpose is also clarified in the Act itself. Then, as usual, every Act has a section for making rules. So, this Act has also a section, even though it is a very short Act, only 4 or 5 sections are there in it. But out of that, one section is there for making rules. So central government may, by notification in the official gazette, make rules for carrying out the provisions of this act. So accordingly, central government has made rules which are very comprehensive. And now initial rules were made in 1981. They were further modified to meet the objective of the situation in 2003 and during other periods. And latest is the rules framed by it in June 2022. Now, this particular rule entirely replaces the earlier rules, and it sets out the detailed procedure for the process of forest clearance by the user agencies. That means authorities which are going to, which intend to establish any project where some diversion of forest land is required, and such authorities are necessarily required to take permission from central government for diversion of forest land. So now two stages, even though this was there earlier also in principal approval and final approval, but it has been clearly defined in this particular rule of 2022. Now the user agency shall make an application to the state government or union territory administration for approval of central government under section 2 of the act for de-reservation of forest land, use of forest land for non-forest purposes, or assignment of lease in the specified online forms to be notified by central government. Now this procedure is already online. So now here I am basically mentioning the broad features of the rules, because the rules itself runs something around 13-14 pages. So entire thing cannot be covered here. So broad features as applicable to this irrigation and hydroelectric project, because such projects required diversion of forest land in a larger quantity. So very broadly, I am mentioning here. The state government and unitary administration may by an order constitute a project screening committee to examine the completeness of the proposal submitted under clause 1 to 3 of the section 2 of the Act. Then this nodal officer, any forest officer, I mean some conservator of the forest or some other officer in the state government is designated as nodal officer. And then whenever this project is submitted to project screening committee, then it examines the completeness proposal from completeness point of view. And then this screening committee is satisfied that the project is complete in respect of all details, then it accordingly recommends it to the state government, and then the state government then submit the proposal to central government. Then under central government there are two-tier process. So one is this regional office, and there in regional office there is a regional empowered committee, and then there is under Ministry of Environment and Forest there is a advisory committee. So composition of this regional empowered committee and advisory committee is already given in the recent rules. And then advisory committee advised the union government for grant of approval under section 2 in respect of proposals referred under subclause B of clause 5 of rule 9, and any matter connected with conservation of forest. Because here I am referring to clause B only, because in other clauses only other clauses are dealt by the state government level or regional office only. They do not come to the forest advisory committee at the central level. So now this is the procedure prescribed for the advisory committee to examine the proposals, and it has to give a recommendation to the central government for consideration. Then while giving recommendation, it may impose conditions or restrictions and such mitigation measures which in its opinion would offset the adverse environmental impact. And then central government shall, after considering recommendation of advisory committee, grant in principle approval, subject to fulfillment of stipulated condition, or reject also. Both can be done. And then communicate the same to the state government or unitary administration as the case may be, and to the user agency also. That means either some irrigation department of the state government or some private developer for hydroelectric project or railway authority and any such things. Then this is further procedure for communicating the in principle approval of the proposal. Then then further process is there for because there are some conditions mentioned in the in principle approval. So the concerned user agency has to submit another report to the central government through nodal officer for compliance to those conditions, and then the central government is satisfied that the conditions set in the in principle approval have been complied with, then it grants final approval. So these two-tier process is there now in the rules which have been made in 2022, and the detailed things are available in the website of Ministry of Environment and Forest. And then online procedure has been made by put in place by the MOEF, and detailed functioning of the same is being looked after by them. Then we come to the groundwater. Now the environment part is over now. Water pollution and environment protection is over. Now we come to the groundwater regulations. So here very old act is there, Indian Easement Act 1882, which basically governs the use of groundwater by the individuals. So under this act, easement is defined as a right which the owner or occupier of certain land possesses as such. As such means being owner or occupier, as for the beneficial enjoyment of that land, to do or to continue to do something, or to prevent or to continue to prevent something being done in or upon or in respect of certain other land not his own. So this is what is this is the definition of easement, and essentially what means is that any person who is owning a land, so water under that land belongs to that person, and even water on the surface of that land, if it is not part of flowing stream, belongs to that person. So that is what this Easement Act tries to define. Now this is very old legislation, and now the specific provision under section 7G there for use of water under the land or on the land. Both things are there. Yes, and the section is mentioned here very clearly. Now, because the now so far only these provisions were there for use of groundwater. So now this groundwater is being used for irrigation also, not only for drinking water, but especially where the flat land is there and water is available just below the ground. So it is used for irrigation also for the local area or area around the well. So because of this, the groundwater levels in certain part of the country have declined to a alarming level, and the replacement to the groundwater is not to that extent to which the depletion is there. So because of this, the central government in 1986 or so, or after 1986, constituted the Central Groundwater Authority under Section 3.3 of Environment Protection Act. Now, under Section 3.3 of the Act, there is a provision for constitution of authority. So under that authority, other authorities have under that section, other authorities have also been constituted for environment appraisal. But this authority has also been constituted utilizing the powers under that section, because water in any case is part of environment. So for the basic objective is the regulation and control of groundwater by industries, mining projects, infrastructure projects, etc. in the country. And the has for regulating the activity and the procedure to be followed by this authority, the Department of Water Resources, River Development and Ganga Rejuvenation under Ministry of Jal Shakti has issued guidelines for regulation and control of groundwater extraction in September 2020. Now, these guidelines advocate a participatory approach for sustainable groundwater management in agriculture sector, including working towards crop rotation, diversification, and other initiatives to reduce over-dependence on groundwater. So, CGW and states issued no objection certificate for the extraction of groundwater to various industries, project proponents as per their jurisdiction and as per the extant guidelines. Now, CGW is regulating groundwater in 20 states UTs, and in remaining states UTs, regulation is being carried out by respective state government UT administration. Then there has been some thinking that there should be this the use of groundwater should not be the exclusive privilege of the owner itself and as provided under the Indian Easement Act. But because the nature of groundwater is such that if over exploitation in one particular state affects the availability of groundwater in the surrounding areas also, and even maybe on the village basis or this block basis also. So thinking developed in the ministry to have some kind of act to regulate, protect and manage the groundwater use. So accordingly, model groundwater bill, because water being state subject, no legislation can be passed at the central level. So that is why a model bill was developed for conservation, protection, regulation and management of groundwater in June 2016. Now, the objective as bill is to ensure groundwater security through availability of sufficient quantity of appropriate quality of groundwater to all stakeholders in rural and urban areas. Then model bill proposes the demarcation of groundwater protection zones based on the assessment conducted by Central Groundwater Board and state government. It also provides for groundwater committees. Then these committees will be responsible for protection and management of groundwater. Then at the district level, district groundwater council should be formed, and so on and so forth. And the further point, the groundwater for industrial use or infrastructure will not be obstructed without issuance of an authority by the appropriate government. So industrial and bulk groundwater use will be priced. So all these things, these are there in the model bill. Now, then what has been done is that this bill was circulated to all states for adoption by them. And if they think they can make some modification in the provisions of the bills, it was not compulsory that they should adopt it as it is. So now, as per the latest information available on the website of the ministry, 21 states have adopted and implemented the model groundwater legislation with certain modifications suiting to their needs. So this is a rather very good response to the proposed legislation by the central government. Now, Dam Safety Act is very important act which has been passed in 2021 by the Union Parliament, and it is under entry 56 of the Union list, which is available to the central government for passing laws for regulation and development of interstate rivers. The objective of the Dam Safety Act is number one, to provide surveillance, inspection, operation, and maintenance of the dam for prevention of dam failure related disaster. To provide an institutional mechanism to ensure their safe functioning and for matters connected therewith or incidental thereto. Then third thing is to evolve uniform dam safety procedure across the country. Pre-post inspection, emergency action plan, comprehensive dam safety evaluation, dedicated funds, etc. And then it is applicable on the dams with a height of more than 15 meters or even below that also, but with certain other design and structural conditions. Now, under this particular act, there is a provision for constitution of two-tier bodies at the central and at the state level. At the central level, there is a provision for this National Committee on Dam Safety and National Dam Safety Authority. And at the state level, there is a provision for the State Committee on Dam Safety and State Dam Safety Organization. So all these have been constituted by the union government and even the state government. All 31 states have done it. Now, this details of this bill and the actions taken on the provisions of the act, sorry, not bill. These are available on the website of CWC itself. So one can access and go into the details of the provisions of the. Hello? Hold on. Okay. Hello, sir. वो फाइल तो नहीं, पहले फाइल तो आ गया था, वो कुछ था शायद डिस्कस करने के लिए बाहर भी कर। जी सर। हाँ ये सर, ठीक है। ओके। Okay, so provisions of this Dam Safety Act are already available on the website of CWC, and one can interested can go into the details of this and the follow-up action taken on the provisions of the act. Now this draft National Water Framework Bill. So this is basically as a follow-up to the provision in the National Water Policy 2012. So what policy says is that there is a need to evolve a national framework law as an umbrella statement of general principles governing the exercise of legislative and or executive or devolved powers by the center, the states and the local governing bodies. So what it means that within a policy, there should be another policy of for addressing the specific issues which will have a statutory backing. That is what it means. Because it umbrella statement of general principles. So that's what it means. Policy means contains the principles only. Now it further provides that such a framework law must recognize water not only as a scarce resource, but also as a sustainer of life. Again, this is provision of the policy. So now as a follow-up to this provision, Ministry has prepared a draft framework bill in 2016, which seeks to provide an overarching national legal framework based on principle of for protection, conservation, regulation, and management of water as a vital and stressed natural resource, under which legislation executive action on water at all levels of governments can take place. So it is just I said, my own understanding is that it is a policy within policy, but with statutory backing. The bill states that every person has a right to sufficient quantity of water. Some quantity is mentioned in the bill, but now going into that much detail is not required, as we will see later in the presentation. Within easy reach of household, regardless of one's community, economic status, land ownership, etc. The bill aims to develop and manage river basins in an integrated manner to provide equitable share of water. So these are all very high and ideal objectives in the bill. Again, this is the provision in the bill. This regarding state government prepare and oversee implementation of water security plan. Then water pricing. So there will be provision for water pricing also in the bill. Now, what is the present status? So bill was circulated to the states, UTs and concerned central ministries for obtaining their comments. Comments have been received from 11 states. And whereas interim response have been received from 5 states. So then what happened next? Now that we will come to this latest status of the bill later. Now coming to this draft river basin management bill. Now this is another bill which was in the making since what it basically replaced the existing River Board Act to provide for river basin authority for regulation and development of interstate and river basins. And not only full river basins, but even sub basins can also be the unit for establishment of river basin authority. Now it strives to work on the principles of participation, cooperation, equitable and sustainable use of water, conjunctive and integrated management of water. Now in the schedule to the bill, there are 13 river basins for each river basin authority they have proposed. And because these are in the schedule, so they can be changed anytime by the central government. And it proposes two-tier system of the River Basin Authority, a governing council and executive board. Then there is provision for setting up advisory council and the chairman of governing council. Then basic function will be the preparation of a river basin master plan, and it will have everything there in the master plan. And then the recommendation made by River Basin Authority shall be binding upon the government, means either state or central both. The bill also proposes a method of persuasion, and there is a provision for how to resolve the dispute. So now persuasion, conciliation, and mediation by the government council in case of any dispute and difference arises between two or more government interested regarding any recommendation, measures, benefits, etc. Then if it can be essentially this is the in a nutshell what this River Basin Authority bill intends to achieve. Okay, this is again continuing with the River Basin Authority method. Okay. So then, as I said earlier, the bill once this bill is done, will stand repealed. Now, now what is the final status of these bills? So now this is final status here. Now a memorandum of understanding has been signed on 2nd March 2022 between DOWR, RDNGR, Ministry of Jal Shakti and Vidhi Center for Legal Policy for preparation of draft model State Integrated Water Resource Management Bill 2023 with aim of amalgamating following draft legislations into a model state law. Draft National Water Framework Bill, Draft River Basin Management Bill, and these are some of the bills which I have not discussed, but they are also in the making for a long time. So this draft National River Ganga Bill, model for floodplain has been done many times. Now latest is 21. Model Groundwater Sustainable Bill 21. This is another bill. That 2016 bill is separate. Then Draft River Regulation Zone Bill. So all the bills now are proposed to be amalgamated into one bill, and task has been given to this Vidhi Center. Now they have done it. As per the information available with me, they have done it. And interesting thing is that now this bill, amalgamate bill, will not be able to interstate river basins. It will be applicable to intrastate. Maybe intrastate have been defined in a different way in the bill, which I have not seen. But my understanding was that intrastate means a basin which is entirely located in one state. And with this, I conclude my discussion on the overview of existing and proposed regulation in water in India. Thank you.
Thank you, sir. Now the floor is open for question and answer session. Those wants to ask directly question to our speaker, they will ask, or if or you can write down your question in the chat box. Then we will answer your questions. Participant or officer can ask their queries, their question directly to our speaker. Now floor is open for question answer session. Yes, any questions, please? Yes, any questions? Okay, if there is no any questions, then queries, then we will conclude the session. Any questions, please? एक minute. Sir, now there is one question from Bindia Panchal. She is asking, nowadays sports activities are planned by tourism department in many reservoirs. Are there any regulations for that?
I think concerned reservoir authority has to give permission as per the operative rule of the reservoir. There is no, there may be some regulations in the respective states, and as per, so it is for the concerned reservoir management authority to decide and take action.
Okay, thank you, sir. Sir, next question. During distress year, can upper riparian state stop release of water to lower riparian state? Please guide on the existing law or act.
No, there is no such law which prevents an upper riparian states to stop water reach to the lower riparian states. Now, what happens is that in a particular river basin, either there are some agreements for use of water, or there are some decisions of the tribunal. Now, in these agreements or in the decisions of the tribunal, there is a provision for sharing of water during the distress years. So there are some. So in case of some base, there are authorities which are trying to make a balance between the upper riparian states and lower riparian states based on the provisions of the agreements. So these are the matters which are internally decided by concerned regulating bodies or authorities, and there is no express law in this regard.
Thank you, sir. Sir, next question.
Yes, now
Next question. Whether environmental clearance is required for dam-based large water supply projects?
no, there is just I mentioned that in 2014 or something, amendment has been done. If there is some project which is trying to supply water for drinking water purposes, and it involves submergence more than 5,000 hectare or something, then that will come under the environment clearance.
Thank you, sir. Any more questions, please?
Somebody is saying, please just share this PPT. Okay, this will be shared. No issue.
Yes, sir. We will share, sir. Any more questions?
Brijesh Kumar Ayog Krishnal Award, I think. Someone is seeking. It is available on the website. It is available on the website of CWC. I will send the link. Vijay Diwan, I think. Everyone.
Yes. Any more questions, please? Yes, Uddar sir. Uddar sir,
आप इधर आवाज आ नहीं रही.
एक मिनट. हाँ, उद्धर सर, आपका माइक जो है ना, माइक ऑफ है. उद्धर सर, आपका माइक ऑफ है.
Yes, समझ गए. Good morning, sir. Good morning to everybody. And thank you, Pandey sir, for enlightening on a very crucial issues. Now, my point is, there are several acts, rules, and regulations for protection of environment, forests, water bodies, and all these things which come under the broad category of environment, including water. I have been in the field for the last 30 years in this water sector, water and land management.
Okay.
Painfully, I share that the field condition is so bad. Whether it's politicians, bureaucrats, engineers, officers, common man, farmer, or anybody, we're all affected by serious field level problems of pollution, whether it's a gutter in the city or salinity and waterlogging in large areas in field levels, or, sir started with water pollution. That's why it appealed to me. So the field level situation is very, very undesirable. We have all a good intention, constitutional provisions, rules, regulations, acts, and also we have institutions, bodies, boards, etc. Somewhere we are not able to tackle this issue very seriously. I know in such a condition, democratic setup, it is very difficult. And also with poverty and all these things at the ground level, also pollution and mismanagement is also very difficult to totally eradicate. But I would request this August body to deliberate on how best we can empower authorities. Number one, empower authorities to regulate and control the pollution, water pollution, in air pollution, then land degradation, etc. Number two, many people try to deny the mobilization or capacity building of the stakeholders. But as I've been involved in capacity for the last several years, I feel strongly that the people's involvement, as also acts the national water policy and many others, people's participation is equally important. But unfortunately, these are denied or not given priority both at center and national level, state level. I feel they're wonderful, more than 150 people of the top brains are sitting together. Empower officers, bureaucrats, and the field level functionaries, and also raise the level of capacity building and bring these very crucial issues on priority for both implementation and for national debate. Thank you very much, sir. I want your reaction regarding what best can be done. I don't want that, these acts are there, everything is there. But let's see, the ground reality is very undesirable. What can be done? Please, sir.
I think in your question, you have given solutions also. So what I will suggest to Mr. Patil, that perhaps he can have some kind of session on the implementation aspect of these acts, and where some expert speaker who are in the field of implementation of provisions of these acts can contribute and give their suggestion, including Poddar sir.
Yes, sir.
Thank you.
Sure, sir. Thank you, sir. Sir, Tharija, sir.
Thank you. Pandey, sir, thank you. Please go ahead.
First of all, it's a real informative and very educative kind of a presentation.
Thank you, sir.
I feel proud that so much of a work goes on in the backstage, and Central Water Commission plays a very important role. But my point is that all that contributions of Central Water Commission which you have spoken, is it listed on some site so that individuals have a possibility also to add and to get updated?
If I have understood the question, sir, you are talking of contribution of Central Water Commission, which is available on the public website. But perhaps you are referring to my previous presentation. Today, I think I have not talked about.
Yes. Yes.
Yes. So, contribution of Central Water Commission is available. There is one book by Dr. Ambedkar. It is available on the CWC website. And then there are CWC publication on legal instruments. So there is a publication volume 3 legal instruments. It is also available on the CWC website. Sir, I will give you the link if you share through Mr. Patil your details, email, etc.
Yes, sir.
Then I will give you the link for those things, sir.
Pandey sir, those whatever is published, I have read and I have access to. But beyond that, because the individuals also make a lot of contribution. Like we were thinking of 75 years of CWC, and what you have spoken in your last presentation is all that not listed
Sir,
because
there is some interruption. There is some interruption.
is it? Am I audible now?
Yes, sir. You are audible now, sir.
What I'm saying that
Sir,
should I speak?
Yes,
yeah.
sir.
Last presentation of yours, you spoke something which needs to be listed, and again CWC officers silently keep on playing very important role in various meetings. Like there are so many issues posed to Central Water Commission officers, and we all consider that that's a part of my duty. But if they are listed, they are a part of your duty, but they can motivate and speak volumes about the contribution, because water is such an important sector. Whether you take dam safety, you take design, you take water management, or water planning, in all those areas, individuals keep on playing their role, but they don't consider it worth recording. But when we discussed during Mr. Masood's days, 75 years of Central Water Commission, that time we were thinking that when we were discussing that this is what we have done, everybody was feeling, my God, we didn't know all these things. So what you have said, why not we have a running kind of option where individuals can list, and every year there should be a kind of a finalization. Can you initiate? Probably NWA or some institution can take over that work. Have I made my point clear?
Yes, sir. So, sir, I will submit that, sir. Now there is an initiative in the Central Water Commission at headquarters that all the persons who are presenting their papers here and there, that should be available on the website also of the CWC, and there should be a dedicated link for that. So that is one initiative, and I think Mr. Pan Patil will now making part of some kind of publication.
Yes, sir.
The lecture, the presentations which are being made here. I think he can elaborate better. Mr. Pan Patil.
यस सर, हम लोग जो है इसको कंपाइल करके करने वाले हैं सर, कंपेनियम टाइप में जो है इसको हम लोग बनाने वाले इस बार, एंड देन वी विल शेयर टू ऑल.
अच्छा, बाद में बताओ.
बट साइलेंटली बहुत सारी कंट्रीब्यूशंस इंडिविजुअल्स कर रहे हैं, वो लिस्ट नहीं होती. पेपर जो पब्लिश करने का कल्चर है वो सेंट्रल वाटर कमीशन में इतना डोमिनेंट नहीं है, बिकॉज आपको इंडिविजुअल के पास जाके भी कई बार पूछना पड़ता है, भाई क्या चीज खास की तुमने, एंड देन ही कम्स आउट, एंड समटाइम्स इट बिकम्स really important, and he may not be giving that importance to that issue.
Yes, sir, there is an initiative for this purpose, sir. This,
okay. Sir, this time जो है sir, now NWA is taking initiative to publishing compendium on both webinar series on Interstate River Water Dispute Act as well as International Water Cooperation in India. We will publish, sir, both compendium publish for people, as well as we also keep this copy on CWC as well as NWA website also for public purpose. Sir, next question. Is there any provision in Water Act for the protection of river ecology and self-purification capacity of rivers?
No, in the act, I think you can read it in a way you want it, because there are general provisions and you can apply it this way also. So I think details are being, because the act is being implemented by Ministry of Environment and Forest, and they are doing so many things in the field of river ecology and other things. So they are, I think, doing under the provisions of this Act 1986, then Environment Policy 2006, and so on and so forth.
Thank you, sir. Any more questions, please?
In this, Indian urban rivers are losing this self-purification capacity, and with the STPs we cannot manage in keeping urban rivers healthy. So rivers have to have the self-purification capacity. So in that regard, what act through the act can we like protect these rivers to have this self-purification capacity, like maintaining DO to maintain the river ecology and all? Because nowadays we see urban rivers, most of them losing their self-purification capacity and highly polluted. So only managing with STPs, it is not cost effective and very difficult. So any law provision that river should maintain this self-purification capacity and river ecology?
I think this is something related to Ministry of Urban Development, and they have some kind of guidelines, I think, as of now, for self-purification, for measures to be taken for self-purification or maintaining the quality of water in the river. And as Mr. Poddar said, it is question of implementation only. So that part is, of course, not that up to date. But there are some guidelines in the Ministry of Urban Development for this purpose.
Okay, thank you.
Thank you, sir. Yes, any more questions? Any questions, please? Okay, then now we will conclude this session. On behalf of National Water Academy, Central Water Commission, Pune, I extend my heartfelt gratitude to all the esteemed participants, speakers, and attendees for joining us today for this enlightening webinar on interstate river water disputes in India. It has been an intellectually stimulating and enriching session where we had opportunity to hear from renowned experts. His diverse perspectives and valuable insights have shed light on complexities of water allocation, management, and legal framework surrounding interstate river water disputes in country. We are extremely grateful to our distinguished speaker, Shri BP Pandey sir, Chief Engineer, Central Water Commission, for sparing his precious time and sharing his extensive knowledge and experience with us. Their comprehensive presentation have not only deepened our understanding, but also inspire us to take closer look at the pressing challenges and potential solutions associated with the equitable sharing of water resources in India. I would also like to extend special words of thanks to all participants who actively engage in the panel discussion as well as question answer session. Your contribution enrich the deliberations and help a vibrant exchange of ideas. Furthermore, I would like to express our sincere gratitude to Chairman and ex officio Secretary to the Government of India, who is driving force behind the various activities of National Water Academy, and with his generous support and guidance making NWA to venture ahead. I also thanks to Chief Engineer and Head of National Water Academy, Shri D.H. Chaskar. Last but certainly not least, I would like to thank our dedicated team, technical team, and support staff who work tirelessly behind the scenes to ensure the seamless execution of this webinar. These efforts and meticulous planning have contributed to the success of today's event then thank you once again to everyone who has been part of this webinar series. We look forward to future endeavor and collaboration in our pursuit of resolving interstate river water disputes in India. Thank you. Our next session will be on 31st August 2023, and the subject will be National Water Policy. There will be a renowned speaker to speak on this topic will be Shri A.B. Pandey, former chairman and ex officio secretary to the government of India, as well as Secretary General of ICID New Delhi. Okay, thank you. We will meet on next session on 31st August 2023. Thank you. Namaskar.